Good morning, this is your Kelso Report for Tuesday, May 8th, and I'm your host, Clark Kelso. Today we have cases involving jurisdiction of the federal courts, a death penalty decision, a product liability decision, and a criminal law case. We begin with the Ninth Circuit in a case involving the jurisdiction of the federal courts. In this case, two non-profit organizations, Veterans for Common Sense and Veterans United for Truth, sued the Department of Veterans Affairs seeking broad structural relief to correct delays in the provision of mental health care and the adjudication of service-connected disability compensation claims by the Veterans Administration. The complaint made it clear that the relief it sought would require the district court to overhaul the manner in which the VA provides mental health care and adjudicates claims for benefits. Well, in Veterans for Common Sense versus Shinseki, the Ninth Circuit in bank held that the federal district court lacks jurisdiction to grant the relief requested because Congress has by statute placed judicial review of claims related to the provision of veterans' benefits within the exclusive purview of the United States Court of Appeals for Veterans' Claim and the Court of Appeals for the Federal Circuit. In particular here, the in-bank majority joins other circuit courts that have construed Title 38 U.S.C. Section 511 as precluding jurisdiction over a claim if it requires the district court to review VA decisions that relate to benefits decisions, including any decision made by the Secretary in the course of making benefits determinations. Well, the broad relief sought in the plaintiff's complaint would clearly have involved reviewing decisions that relate to benefits decisions as well as decisions by the Secretary. The dissent to the in-bank closes with the following wry observation, quote, "The majority's holding thus reduces itself to a catch-22. To challenge delays in the system, you must bring a systemic claim and not just an individual claim. But if you bring a systemic claim, it has to be treated as an individual claim and you must suffer the delays in the system. Get it?" Close quote. I think the correct response is, sounds about right for Congress. Next we have a death penalty decision. The California Supreme Court has affirmed another death penalty appeal, this time in People v. Jones, where it took a unanimous court 114 pages to dispose of all of the issues. The appeal came from Riverside County, where a jury convicted the defendant of the first-degree murder of his elderly neighbor and found true the three special circumstance allegations that the murder took place during the commission of a rape, sodomy, and burglary. The jury additionally convicted the defendant of the arson of the victim's home and also found true various sentencing enhancement allegations. Following the penalty phase of the trial, the jury returned a verdict of death. The California Supreme Court found no error anywhere in the proceedings. Next, we turn to an interesting product liability decision. It's a case that we essentially have seen about a week and a half ago. Agreeing with the first division of the First District's recent decision in Shields v. Hennessy, the fifth division held in Betancourt v. Hennessy Industries that the plaintiffs could in fact state a claim for product liability for injuries resulting from exposure to asbestos because the defendant's brake arcing machine, when used as intended to grind and shape brake linings, inevitably leads to asbestos dust being present in the workplace. There is, in this opinion, no new law here because we had this decision only a week ago from a different division coming to the same result. It is just a reaffirmation of the conclusion that the California Supreme Court's decision in O'Neill v. Crane, where the court held that a product manufacturer generally may not be held strictly liable for harm caused by another manufacturer's product, does not apply in the facts of this case because the product in Crane was not designed to be used exclusively with materials containing asbestos, whereas the brake arcing machine has that precise and exclusive purpose. We closed the criminal law case from the 4th District. In People v. Dunn, the defendant appealed the judgment, sentencing him to prison for 25 to life, after a jury found him guilty of committing sex crimes against an 8-year-old relative and infecting her with syphilis. The defendant argued the judgment must be reversed because, first, the trial court abused its discretion in denying his motion for mistrial, which was based upon the failure of his own retained expert witness to appear at trial, and second, trial counsel provided ineffective assistance by failing to subpoena the expert witness to appear at trial. The 4th District rejected both arguments and affirmed the judgment. As for the expert's sudden failure to appear, the court faulted counsel a bit for not taking more aggressive steps to secure the expert's appearance or otherwise to present the expert's testimony, but ultimately decided that it didn't matter because the expert's testimony, as described by defense counsel, was unlikely to make any difference whatsoever in this terrible case. Her testimony would be to the effect that if there had been penetration into the vagina, there should have been serious tearing, and there was none. But that degree of penetration is, of course, unnecessary to commit the crime, and the expert's testimony was therefore not inconsistent with the expert testimony presented by the prosecution. And, of course, there's that case, that transmission of syphilis to deal with in the case. Having found the absence of the expert to be utterly harmless, the court easily rejected the ineffective assistance of counsel claim. And that's it for today's Kelso Report. Have a great day in the law.